Welcome, eavesdroppers, to Conversations in Coffee, the video and audio podcast where stimulating discussions flow as smoothly as a fresh cup of coffee. I'm Dr. Joy, the host of this show. Join me as we delve into captivating topics with fascinating guests, which will lead to thought-provoking conversations and heartwarming stories. Are you into the latest trends? Well, we're here to caffeinate your mind and ignite your curiosity. So grab your favorite mug, settle in, and let's brew up some captivating conversations together. This is Conversations in Coffee with Dr. Joy, where every sip sparks a new conversation. Today's episode, Elder Law and Estate Planning. Hello, everyone. Welcome to Conversations in Coffee. I'm Dr. Joy, the host of this show. I'm glad you are here eavesdropping on the conversation. Today, we have with us Michelangelo Mortellaro. He is the founding attorney of Mortellaro Law, where his practice focuses on elder law and estate planning in the Tampa Bay area. What is so humbling about attorney Mortellaro is that he is very active in the community. He devotes his time and resources to educate the community on elder law affairs, estate planning, assessment protection, and Medicaid and VA benefits. That is why we wanted him on the podcast today. He has also been a contributor for various media outlets and featured on Fox News, ABC, CBS, and Bay News 9 throughout his years of experience. What a way to give back and educate the public. We sincerely thank you, Attorney Mortellaro, for giving us the opportunity to have a conversation with you today. So, eavesdroppers, are you ready for a great conversation with a hot cup of coffee? Let's begin with the most important question for Attorney Mortellaro, and that is, can you tell us more than I've shared with our eavesdroppers about who you are and why is your job important? So take it away.
Thank you so much for having me. Attorney Michelangelo Mortellaro here. I have been an estate planning, elder law, and asset protection attorney in Florida for over 17 years. We actually have two locations, one in the Tampa area and the other across the state in Martin County in Stuart, Florida. But we do serve families all across the state of Florida, all 67 counties. And we have served over 8,000 families in the last 17 years in our practice areas of estate planning, elder law, and asset protection. So, as you mentioned before, I really like leading the practice through education. And I find that people are generally smarter than oftentimes they get credit for. So if you give them the right tools that they need and you educate them on where they're at and potentially what their options are and why those options might be advisable, might put them in a better, safer, more secure place, then oftentimes people will appreciate that education and decide to retain my law firm to provide various services. We've been blessed over the last 4 consecutive years to be the best and highest rated estate planning and elder law firm in the state of Florida. And I truly believe it's a testament to our lead by education and make sure that everyone in the law firm loves my clients as much as I do. And then everything works well.
Wonderful, wonderful. You really summed it up. And so thank you for sharing that. That is what our podcast is all about. We love to educate the public on things that you don't even really think about. When we were talking about having you on, it was more of, what are we going to do? Are people really interested in this? And when I started really kind of looking it up, like, yeah, people are, because I'm interested to find out more what you have to say, especially when it comes to our elders, because we get to the point in life where we have to make those decisions, and sometimes we just don't know what to do. But with education like what you're giving, education like this podcast, we're able to give that to the public, and hopefully they will hone in on that and get what they need out of it. So thank you for that.
I appreciate that. So old is always a moving target. And when we say when we're getting older, we can always point to someone older than us. So we like to kick the can down the road. But what I tell people is we're all on the express train to Oldville, and we're going to be there. If we're blessed enough to arrive at Oldville, we want to make sure that we are prepared legally and financially, because getting older isn't for wimps. And sometimes there are tough decisions that need to be made from a care perspective, from a legal perspective, and from a financial perspective. So we're always best served by being educated as early in the process, preferably before we need those types of services and care. But the reality is most people kind of bury their head in the sand. They don't want to talk about it, deal with it. And so oftentimes families come to us in the middle of a crisis. Mom's just had the stroke. She's in the nursing home. She just got a bill for $20,000 for the first month. And then they say, well, what do we do? And the good news is Florida is the best state in the country if you happen to get old and sick, with respect to being able to shelter assets and get public benefits turned on without having to spend everything down and go broke in the process.
Oh, wow. Oh, wow. That is good information to know. And you are correct. When we want to know about the information, it is either right then and there at the emergency, or, later on in life when you're really trying to figure it out and you haven't figured it out. So thank you for that. Now let's dive into some of these questions. Is there a difference between elder law and general practicing law?
Absolutely. So, every attorney has areas of focus, or at least they should. Some attorneys truly are a general practitioner, and I certainly respect those folks, because trying to be a master at one area is difficult enough. I couldn't imagine what it's like to try to be a master at every area of law when you think about how many different things lawyers do. If you're good at all of them, then I give you much respect, because you're way smarter than I am. But we like to focus on our niche, which is estate planning and elder law. And so to kind of narrow your question and then answer it, there is a big difference between even estate planning attorneys and elder law attorneys. And I analogize it to the medical field. So all cardiologists are MDs, but not all MDs are cardiologists, kind of that line of thinking. So all elder law attorneys are also estate planning attorneys. We draft powers of attorney and healthcare surrogates and wills and trusts and special needs trusts. We both do all of those things. However, big distinction is that elder law attorneys do it with an eye towards getting older, needing care, and figuring out how do we get the care that we need without going broke in the process. So to give you one quick example, just in some documents that share the same name, but that have very different qualities about them. If you go to a general estate planning attorney and you get a durable power of attorney, and that's a document that allows you to appoint someone who you trust to help you make legal and financial decisions in the future if you start needing assistance with making those decisions. So a general estate planning attorney will most of the time give you a power of attorney document that is somewhere between 5 and 12 pages in length. And then 12 pages sounds like a pretty robust document. However, the reality is a good elder law power of attorney, like the ones that we provide, are 32 to 35 pages in length. So instead of 5 to 12, we're at 32 to 35. The difference in page count is all of the language, including Florida-specific strategies, that if the language is not specifically written into your document, you literally can't use those strategies if you get old, get sick, and then need care. So the devil's in the details, and many people have a false sense of security of, oh, I went to an estate planning attorney for mom, and just last month we got a great power of attorney for mom, so I'm set for life. Well, the answer is maybe. If it has elder law language in it, then I agree, you are set for life. If it doesn't, then you may find the unfortunate situation where mom has the stroke or mom's dementia gets bad enough where she loses legal capacity to sign new documents. Mm-hmm. And then you realize you have the 5-page document. You really needed the 35-page document to prevent mom from having to spend all of her money down in the nursing home and go broke.
Oh, so what do you do? And the reason I'm asking that, because for an example, reality check for myself and my sister. My dad, he had an emergency surgery. We got power of attorney for him. But he's getting older. Do we need to now go to an elder law firm and now add additional things in there to continue to take care of him? Because my thought was, oh, I have power of attorney, so I can do whatever I need to do for my dad forever more,
So the litmus test is really page count. If you go home and look at dad's power of attorney and it's less than 30 pages in length, yes, there's a good chance that it's missing some language that he might need in the future. Now, I'm generalizing because there are some people whose finances are simple enough where, they're living check to check on Social Security at $700 a month and they have $50 in the bank and they don't own their own house. Well, that person may not need a 30-page power of attorney, but the general rule is that as we get older, we might need benefits. So if dad happens to be a veteran, then there are potentially VA benefits in the tune of, $25,000, $30,000 a year, tax-free direct deposit that we might be able to get for your dad or someone else's dad or someone else's mom who is a veteran. And so we may want to or need to create trusts, move money, invest in things, create contracts. All of that specific language needs to be in the power of attorney in order to make the maneuvers and get the benefits without getting pushback from the government entity like VA or Medicaid.
Mm-hmm. And are you stating that if someone is in that predicament, before they, I guess their parent or elder, before they get to the point that they're not able to make decisions, you need to go ahead and change that? But what if you are there where now your parent is not able to make decisions? This is the only POA you have. What do you do?
Well, in that case, we make the best with what we have, and potentially we may need to supplement their document through a guardianship, court-appointed guardianship process to ask the guardianship judge to add effectively, I'm generalizing, add language that wasn't already there so we can get our job done. Problem with that is guardianships take time and cost money. Oftentimes, I've seen $15,000 to set them up just to get in front of the judge to have them add one sentence that we're really needing but missing in our current POA. It's a horrible waste of time and money when we have to try to do it after the fact. However, on the note of capacity, the legal capacity required in Florida for someone to sign a document like a power of attorney is often lower than what most people think. So for instance, if your dad had a cognitive impairment and he's starting to get a little fuzzy on making decisions for himself, as long as when I interview him, he can say, oh yeah, Joy's my daughter, and that's my other daughter, and I trust them to help me make legal, medical, and financial decisions. I know I'm getting older and I know I'm slipping a little bit, but boy, my girls are awesome and I trust them and I know they would make good choices. They'd never steal my money. Like if we have that, we have enough to let dad sign new documents. Some people think like you need to know who the president is and you need to know, different things and dates and times. That helps. And some of that is required for more advanced documents like wills and trusts. But generally speaking, knowing who the players are and being able to articulate that you trust them is often all that we need. So my recommendation for anyone listening would be, if you think your parent is too far down the dementia path or has had a stroke and maybe is nonverbal. I've had people sign documents oftentimes following a stroke that are nonverbal, because we can still communicate through them, with them through head gestures, through pointing to things on paper. And as long as we know they understand what they're doing, If they have a physical disability like a stroke, we can do what's called a notarial signature and have the notary sign for a physically disabled person. So there's a lot of stuff that can be done, but it all starts with a consultation, an interview with a qualified elder law or special needs attorney, depending on your situation, because that will tell you, are we too far down the path, or do we still have a window? And oftentimes we still have that window. We can jump in, get the documents executed, and now we have them for the rest of our life.
Oh, wow. Lots of great information. Thank you so much. And listeners, eavesdroppers, I hope you're listening. This is a lot of information that we are sharing with you. And I thank you so much for opening my eyes, because now I actually know what I need to do, my sister and I need to do to continue to prepare for my own dads.
Okay, eavesdroppers, it's brain break time. How are you feeling about this conversation so far? Are you intrigued, grateful, overwhelmed, and are thankful? This episode thus far has provided us with stepping stones to prep ourselves and our families to plan successfully. Do you have any other questions you would like answered? Ask your questions via the comment section on YouTube or send your questions to us by email. Attorney Mortellaro will be happy to come back for a Q&A at a later date based on your additional questions. Now, let's get back to the conversation.
So my next question would be, at what age should you contact a lawyer, an elder law attorney?
Well, we always say a little tongue in cheek, elder law starts at 40, and you know,
oh no,
yeah, we're all in trouble. But the reality is, elder law is not just the when you slip on the banana peel, break the hip, and end up in the nursing home. Although clearly that's a lot of what we do. But a lot of elder law is coordinating early in your life. So, for instance, one of the big things that we are a proponent of, and we actually sell in our office, is things like long-term care insurance policies. Because the best solution, even though I'm an attorney and I do the legal side of it, I truly believe the best solution for you, your parent, or anybody else is to have a solid insurance product. And it may not be a standalone long-term care insurance. Sometimes it's a hybrid with a life insurance policy and annuity. There's a bunch of different stuff we can do. But the idea is that the more resources we have on tap when we get older and need care, the better quality care we're going to get, the better quality facilities we're going to have access to. And it's going to make potentially a big difference in the quality of life for you or your loved one for their final years. So trying to buy long-term care insurance when you're 80 is way more difficult and expensive than buying long-term care insurance when you're 40. So I have gotten to the point in my practice where I give everybody my elder law documents, because other than killing a few extra trees on more pages, there really is no downside. Because as we all know, you blink your eyes and it's 10 years or 20 years has gone by. So if you have to go through the mental gymnastics of saying, okay, I'm in my 40s and I want to do a will or a trust for my children, so I'm going to go to a general estate planner now, and then I need to put a note on the calendar, in 25 years, I got to go find a new attorney that's going to redraft the same documents with extra language in it. Why bother? Just get it done from day one. Because if you don't need the elder law and asset protection language now, great. I hope you never need it, but it's there and we're prepared, and we don't have to then go back and spend money a second time on the same documents that have better quality language. And since we don't have a crystal ball, things like strokes, things like car accident with a brain injury could instantly change our lives and put us in a situation where we didn't see it coming. And once you lose capacity, you're stuck with what you have. So wouldn't you want to be stuck with the very best, most powerful, most flexible documents that you could get your hands on, whether someone will be caring for you or you will be caring for someone else as the agents on those documents? Let's just get the best. Let's get the best, put them in place, and then cross our fingers and hope we're blessed for the rest of our lives and we don't need that language.
Yes, yes. This is just something I want to ask you. With the many years you have been in practice, how many times, or do you see more often people come in when it's too late, or right at the beginning, like you say, at that 40?
Oh, I wish people came in at 40, but let's be honest, they don't. Everybody thinks they're invincible until they're not.
Yeah.
So we'll start with rarely do people come in at 40 for elder law planning. However, because we do both estate planning and elder law, a lot of the clients do come in their 40s and sometimes even younger when they're having, they're in their 20s and 30s having children and thinking like, boy, what happens if on date night we get hit by the bread truck? Yeah. Who's going to raise our children? Mm-hmm. How are we going to protect our children? Who's going to manage the money? So even for those folks, when they come in young, they're going to get the better documents. Mm-hmm. But I think the short answer is always planning ahead, and that starts with education. And I usually try to run the scenarios by people. One of the big scenarios is blended families. And these days, unfortunately, more and more families are blended where, husband has some children premarital, wife has some premarital, and then maybe they have some together, maybe they don't. I always run through the dynamic. If you guys, are on date night, you get hit by the beer truck and husband dies on impact and wife dies 2 days later is in the hospital, potentially all of those marital assets are going to wife's children because she survived by 48 hours. Flip the script, wife dies on impact, husband dies 2 days later in the hospital. Now husband's kids are getting everything. Do you really want to leave the potential of your children getting zero from your estate because you failed to plan? And so those are the types of things. And as soon as I educate them on, here's what's going to happen if you do nothing, then instantly they are very interested in learning more and protecting their children, as they should be. But no one's ever sat them down and said, here's what happens if you don't do anything.
Yeah, that was a very good explanation. And if I heard that, like you said, I would be doing that. I'm just hearing it now. I just turned 50 last week. And
congratulations. You got me by a few. I'm right on your heels there.
So with that being said, my husband and I, we are thinking more and more about those things. And like with the incident that happened with my dad, that was an emergency. And we never thought like, oh my gosh, we're now POA. We got to make decisions for him. So being educated like this through this podcast and what you do in your community is very, very awesome, because that's what we need. I just hope a lot of people are listening and really getting the answers that they need to know what they need to do to prepare. Definitely. So if you are that person that and you are preparing, what type of information should you bring in if you are coming to talk to an elder law attorney?
So first thing, you want to make sure that you bring in any existing legal documents that you have, even if they're super old. At least the attorney can review them and give you an opinion. And sometimes people will bring me their last will and testament from 1972, and I look at it and I say, all right, you still have all these children? Yes. Have you had any new ones since 1972? No. Do you still want the same people to be in charge? Yes. You want the same children to get the same amount of money? Yes. You're good. I don't care if it's, 50-year-old document, 51-year-old document. Mm-hmm. You're good. And then other times they come in and they say, oh, this was done when, we had our first child and we have 5 and the other ones aren't even named. Mm-hmm. And, everything's changed, or God forbid, we've lost a child and now that dynamic is different and we have grandchildren. So bring in what you have and have a general idea about who do you want in charge. And that could be in charge of your legal, medical, financial decisions during your life. And it could be, or as well as, who's going to be in charge of gathering your assets after you pass away, paying your creditors, and then distributing your assets. And then think about who are your beneficiaries. Sometimes it's easy and it's, evenly to our 3 children. Sometimes it's anything but easy. And there are family dynamics that always make things interesting, of who's getting some, more, less, none, you name it. I think I've seen it, but then every time I say that, I see something new. So think about, who do you trust? Who is honest? Who plays well in the sandbox with the other beneficiaries, maybe? And so those are the types of things to just be thinking on preliminarily, but have an open mind and basically just go, and hopefully you have an attorney that is open and honest and tries to truly help. There are some attorneys, every profession has its bad apples, but in our world, it's folks that meet seniors, people that are much older than the attorney, and don't advise them on things like how a revocable living trust could keep their estate out of the probate process. Because many times the estate planning attorney also practices in probate. And some less scrupulous attorneys may see a client in their 90s when the attorney's in their 40s or 50s and think, well, I'll probably still be practicing when Mrs. Smith dies because she's in her 90s. I'm going to avoid talking to her about the trust and how that can help her save money in the long run. And I'm going to tell her, don't you worry about it, Mrs. Smith. I'll take care of you when the time comes. Trusts are for millionaires and you don't have millions, so don't you worry about it. And then Mrs. Smith dies with a simple will. And then who are Mrs. Smith's children going to call when she dies? Well, her lawyer, and her lawyer is going to say, oh, I'm so sorry to hear mom's passing, but I can help you through probate. And then they're going to charge him tens of thousands of dollars to get her estate through probate. So, the internet can be good and bad. Sometimes people try to do it yourself, and that's oftentimes not so good in technical fields. However, the great equalizer is reviews. So these days, if you disappoint someone or they think you took advantage of them, they have no problem going to Google and telling everybody what they think of you. And so, it's interesting. Oftentimes, people won't go to a new restaurant or stay in a hotel without reading all the reviews. Right. Well, read some reviews on your estate planning and elder law attorney. I promise you, some of them are pretty entertaining and horrifying at the same time. So when you have someone like us that has hundreds and hundreds of 5-star reviews, where everybody says this is a good firm, they love their clients, they took care of us, they saved mom's money, then okay. But when you start seeing patterns of, well, they were nice until I paid them, and then they never called me back, and they never did the work, and they didn't care about us, and they always canceled our meetings. You start seeing that as a pattern, just like a restaurant that says the food's terrible one time, and you have 5,000 good reviews of one bad one. You know what? It's probably a decent restaurant. Yeah. But you start seeing a whole lot of bad ones, you're probably not going to eat there. So if you would use the internet and the independent review process to eliminate a restaurant when you're on vacation, you should certainly use that process to eliminate attorneys who have a bad reputation for taking advantage of people or not doing a good job.
Oh, yeah. Yeah, I'm glad you mentioned that. Yes, that is so true, because I am one to do that. I look at reviews and determine what restaurant I'm going to eat at. But I do that also for other things as well, because the power of the internet now, everyone is on there. And most people, when they are writing stuff, they don't focus on the good, they focus on the bad. So you're going to get those things, and it will let you know, definitely. As you were talking, you were mentioning things such as, power of attorney and trust and your will. Should a person have a power of attorney, healthcare surrogate, and so on? And the reason I ask, because sometimes you think just the power of attorney does everything. But when you have children, more than one, you may want one to do something and another to do something else. What can you tell us what we should have?
Hey, eavesdroppers. We are pausing here, and we will bring you part 2 next week. Do you have any questions that may be on your mind and you want to ask Attorney Mortellaro? This is what you need to do. If you are watching on YouTube, you can click in the comment section and type your question. If you're listening to the podcast, view the show notes to email your questions to us. Attorney Mortellaro has been a great asset to the podcast this week, and we will bring you part 2 of the conversation next week. So, if you love what you're listening to, click the like button and subscribe to the channel to stay up to date on the latest trends, concerning your life.